Can a lawyer take your case and withdraw if it doesn't settle? That's the question I'm answering today. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. So imagine you have a case and you hire a contingency attorney. Now, what is a contingency attorney? That's an attorney who you're not paying a fixed fee to, you're not paying an hourly fee to. The attorney is getting paid contingent on the outcome of the case. So in other words, if you don't win, the attorney doesn't get paid. Or if the case doesn't settle, the attorney doesn't get paid. That's a contingency fee attorney. You typically see it in auto accident cases, medical malpractice, and often it's a case where there's clearly an injury, there's insurance on the other side, and the question is largely how much is the insurance company going to pay out. So you decide that you don't have the money to pay hourly for an attorney, so you decide to give the attorney a percentage of what you recover in the case. That's called a contingency attorney. Now the problem is, what happens if you hire an attorney, that attorney sends a couple demand letters and does a little bit of negotiation, and it doesn't settle? Well, the attorney might say, hey, you know what, I figured I'd put a few hours in, but I'm not going to trial on this case. That could be frustrating for you. You thought you were hiring an attorney who would work this case, and now by the attorney withdrawing from the case, you're concerned it sends a message to the defense, the other side, the insurance company, or whoever you were making a demand on, that your case isn't very strong. In fact, your case is so weak that no attorney will even represent you. So you're thinking to yourself, I really want to make sure the attorney I select who will work for me is willing to be with me in the long haul, not just send off a couple demand letters and see if they get a quick return. Now think about it. If you're a greedy attorney, and I'm not saying all attorneys are greedy, but if you are a greedy attorney, you might say, hey, yeah, I'll take a case, send off a couple demand letters, see if I can negotiate a quick settlement, and then I get a percentage of whatever I recover. In other words, financially, an attorney is incentivized to get a quick settlement. Now let's say, for example, you're an attorney and you put in 3 hours of time, and let's say hypothetically you're getting 1/3 of whatever the client recovers. So you get a settlement offer from the other side for $20,000 after putting in 3 hours of time, which means the attorney's portion is 1/3 of that. I should have picked a number that's easily divisible by 3, but let's say it's a little bit under $7,000. All right, so 3 hours of time, $7,000. That's good money. So as you can see, an attorney will think, hey, let's take this offer. Imagine though, by going to trial, you might be able to recover $80,000. But to go to trial, the attorney's going to have to put in 150 hours. Well, 1/3 of $80,000 divided over 150 hours is a very low hourly rate. In other words, you can see the difference for an attorney. Financially, an attorney who gets a quick settlement can make some good money. But an attorney who has to go to trial may get a low hourly rate if you win, and if you lose, they don't get anything. So unfortunately, there are attorneys out there who will be looking out for their own best interest, not as much their clients, and be willing to do some quick settlements, but not be willing to fight this out to trial. I'm not saying all attorneys are like this, and let's face it, sometimes cases cannot be justified going to trial. Here's what I mean. I one time had a client come to me and say, hey, I've got this case, let's say it's $20,000. Would you be willing to take it on contingency? Now, I usually don't take cases on contingency. I said to this client, though, there's no way I'm going to go to trial on this case. But if you want, maybe we could send a couple letters and see if there's anything here, and maybe we can get something of a settlement. And maybe we do some sort of hybrid arrangement where instead of it being 100% contingency, I'm getting an hourly rate at a discounted rate. So let's say an attorney who's at $800 an hour would agree to a half rate, so that's $400 an hour. And then also a contingency fee, which might be, say, 15% of whatever's recovered. That's a little example. Sometimes attorneys will do $100 an hour plus a larger percentage, but that gives you an idea of what a hybrid attorney fee is. Okay, so you understand the difficulty here with contingency fee agreements. I'll put a little link in the notes below to some warnings I have for people who are thinking about hiring an attorney on a contingency basis, just so at least you are educated before you agree to a representation agreement with a contingency attorney. All right, so can a lawyer take your case and withdraw if the case doesn't settle? The answer is yes. Under rules throughout the United States, an attorney can withdraw from your case. Now, there are some rules about how that gets done, but attorneys can withdraw. How can you make sure an attorney won't withdraw from your case? There isn't a simple way to make sure the attorney won't withdraw, but you could have some agreements regarding under which circumstances the attorney can withdraw. I will warn you though, attorneys are crafty. They're paid to be able to get around language. And so if you're having an attorney draft an agreement with you, most times attorneys are going to be able to draft a contract so that the attorney can get out of it if needed. In fact, many state attorneys' rules permit an attorney to get out for certain reasons, regardless of what the contract says. What can you do to reduce the chances of an attorney withdrawing from your case? I'd recommend asking an attorney the following questions. What is your policy on withdrawal in the event of unsuccessful settlement negotiations? Can you provide a written agreement that outlines your commitment to my case? What is the likelihood of going to trial, and how will you prepare for it? How many cases similar to mine have you handled? How many of those cases went to trial? How many clients have you withdrawn from? By asking these questions and perhaps some follow-up questions, you'll probably get a sense of the attorney's commitment to the case and what the attorney's evaluation will be as far as potentially withdrawing from the case. Not every case is worth going to trial, and an attorney who's committed to transparency and openness will tell you whether your case is likely to go to trial, tell you whether the attorney is willing to take it to trial. Small cases, it's not worth going to trial. All right, what are your rights if an attorney withdraws from your case? For example, let's say the case doesn't settle and the attorney says, you know what, I can't keep representing you. I no longer have confidence in your case. I can't put the time into it for health reasons or for other commitment reasons. I can't keep going on the case. Whatever it is, what are your rights if an attorney withdraws from the case? You have a right to your file. That's the documents in the case. You have a right to have the attorney represent you for a reasonable period of time until you can get another attorney. Now, you're not going to be able to abuse this, but this is to prevent an attorney from withdrawing right before a motion. Or let's say you're going to trial tomorrow, and the attorney says, you know what, I'm withdrawing, I just can't put in the time. Well, that's unreasonable. Courts aren't going to allow that. But don't think you're going to be able to get an attorney to work for you for free for a number of weeks. The whole idea is if there's something big coming up, the attorney can't withdraw right before that. So you have a right to representation for a reasonable period of time until you can find another attorney. And reasonable period is decided by state ethics rules and the courts. And what the attorney needs to do in the meantime is also decided by the court and by those rules. All right, so that's some general guidance on hiring a contingency attorney and trying to protect yourself You can consult with the Bar Association usually, or the State Ethics Board if you have any questions on this, and that would be the board in your particular state. Sometimes the court has a self-help line that you can contact there as well. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. If you find this sort of educational content, you're welcome to subscribe to this channel. You can like this video if you want more content like it, or thumbs down if you didn't find this helpful. Regardless, thanks for watching today, and I invite you to watch more educational videos which help you identify issues to discuss with your attorney and to avoid common legal problems.